Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Thanks for joining the show. Today, our topic is creating and using land trusts to own and convey real estate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our channel. You can find us in two primary places. You can find us in Facebook at INREM, and we'd love it if you'd follow us there and like our content. We're also on YouTube. You can find us at the handle at INREM Podcast. That's at INREM Podcast. Give us a like, subscribe to the channel. That would be awesome. We'd really appreciate it. With that, Sean, give us our legal update.
So today I want to talk about a seller's ability to assign an executory contract. So often when we are dealing with real estate investors and our clients, we're talking about the buyer assigning a contract.
Yeah, I think in every instance, it's always about the buyer, right?
Right, about the buyer. But a lot of people forget that the seller, depending on the language of the contract, potentially has a right to assign an executory or a purchase agreement or an agreement for sale, or other states call it a contract for deed. They have the ability to assign it. And assuming that the language of the agreement doesn't state otherwise. And so the question is, okay, well, number one, why would you want to assign it? And then number two, what are the elements that must be met to establish whether or not the seller can assign? So one instance in which the seller may want to assign it is the seller's entered into a purchase contract with a buyer. And that buyer is maybe not performing under the contract, but the seller doesn't have the resources to enforce the contract one way or the other, either, force the buyer to perform if specific performance is allowed. In Arizona, we can't force a buyer to perform, but in other states like Georgia, as we learned a few months back with our guest Brian Locker, you can seek specific performance of a contract or of a buyer side of the contract in Georgia. So there's some states that allow for specific performance, but let's say the buyer's not performing and the seller just doesn't have the resources to force it, and they want an amount from the property. Well, you can structure a transaction with the seller as, basically the secondary buyer or coming in and saying, okay, I'll make sure you receive X amount of dollars, or I'll pay you X amount of dollars, but you're going to then assign this purchase contract and any further rights in the property to me. And then I'm going to go and either A, enforce this purchase contract, or B, figure out a way of canceling it. And then from there, I have a right to, purchase the property, or I'll then, own the property depending on how you structure the transaction. So you could do, say, a secondary agreement for sale, or a contract for deed, as some states call it, or some other document that basically gives you an ownership, or at least an equitable interest in the property if you're able to cancel that, first contract. But you can have the seller fully assign that contract to you so that you step into the shoes of the seller and you can deal with the buyer on that contract, whether that requires a lawsuit to, for the purposes of cancellation, for the purposes of specific performance, but you can basically step in the shoes of the seller and perform on the seller's behalf, and, potentially reap the benefits of the purchase contract, or cancel it and reap the benefits of the property. The other time that you could step in the shoes of the seller is if the seller's entered into, say, an agreement for sale or a contract for deed, and the other buyer's performing. Maybe the seller just wants money up front. They just want to be out, right? They're tired of receiving payments. They need maybe, an inflow of cash. So you could come along and say, okay, I'll pay you X amount of dollars for this agreement for sale, knowing that, okay, over time, eventually I'm going to make that and more via the buyer's performance. And if the buyer doesn't perform, then I have a right to perform a forfeiture of their interest and basically take the property from that buyer. There's other things to do besides assign the agreement for sale or the contract for deed. And you would have to take an interest in the property, that type of thing. But at the end of the day, you could potentially step in and use that as an investment tool or technique, is to basically take the seller's assignment of an executory contract. Now, the question is what's the law on that? So obviously, if the contract says that the seller can assign either of those types of contracts, then you can do it. Well, of course, it's not going to say that, right? I mean, it's generally going to have a provision, either A, prohibiting it, and then you can't do it, or more likely, and this is the more likely scenario, it's silent. There just is no provision in there one way or the other as to the seller's ability to assign that contract. And in that case, you have to look at, and we covered this a little bit on the last episode, is would the assignment somehow materially impact or affect the buyer in the transaction? No, because really the buyer is performing. They're paying somebody. They're either going to pay somebody upon close of escrow, or they're going to pay somebody as they go to perform under the agreement for sale or contract for deed. So there's no really material change.
They're paying the same amount and getting the same property.
Exactly. Yeah. So there's no material change. And then the second is, well, is it prohibited by statute or law? No, it's not. And so that's the other. And then finally, is it expressly prohibited by the contract? Obviously, if it is, you're out. But if it isn't, and then you can, the seller can go ahead and assign it. So it's one of those things to be thinking about, when you're out there and a seller's like, oh, well, I've already sold it, or I have an agreement for sale in place, or that type of thing. You say, okay, well, what's the performance look like? Are they performing? Is there any way that, I can help you out if you need, cash in the short term, in order to, assist you with whatever situation you may be in, Mr. or Miss Seller type of thing.
Are there circumstances in your mind where you think there is a time where the buyer would even care whether it's assignable or not assignable? I mean, should that be on a real estate investor's radar, that should this clause be in the contract, maybe we want to work through this?
If I'm the buyer, I don't want it assigned. And if I'm sophisticated, I put an anti-assignment provision in that purchase contract. The purchase contracts that I've drafted for clients, both agreements for sale and real estate purchase contracts, always have provisions in there prohibiting the seller's assignment, because you want to know who, at the end of the day, you're going to be, dealing with, and you don't want the seller to send it or assign it to somebody who you can't work with and you're not comfortable with and you've never met. So I put a provision in there to that effect, but there's plenty of contracts floating around out there that are just silent on the seller's ability to assign it. It generally will say that the buyer has the ability to assign,
right,
but it won't say anything about the seller. And the same for agreements for sale, contracts for deed. So I think there's plenty of opportunities there. Obviously, it kind of has to be the right fit, the right situation, where it can be mutually beneficial between you and the seller, but nevertheless, it is, an investment possibility.
All right. With that, we're going to get into our topic today. Today, we are talking about creating and using land trust to buy and sell real estate. Today, our guest is attorney William Bronchick. William is an attorney with Bronchick and Associates, located in Colorado. William, thanks so much for being with us.
Pleasure to be here. And I very much enjoyed your topic, having closed about 1,500 contracts for deed in the last 25 years.
Okay, so you know a little bit about it then.
Yes, I do.
William, tell us about Bronchick and Associates and the areas of practice that you guys focus on there.
Yeah, been practicing for 32 years, primarily real estate. Most of my clients are real estate investors. And with that comes some other types of practice related business entities, asset protection, estate planning, tax planning, and self-directed IRA setups for mostly for real estate investors who want to invest their retirement accounts in real estate.
So it sounds like your career has predominantly been in real estate. How did you end up in there? Was it intentional, or were you like the rest of us lawyers? It was one of those first jobs out of law school, and that's just what you did.
Well, I went out on my practice as a general practitioner pretty much about a month after I was admitted to the bar, which was originally New York. And I kind of fell into real estate. The office that I shared with some other attorneys was primarily real estate. They fed me business, and I became a real estate investor as well. So it kind of went hand in hand. I learned more about real estate investing as an attorney, and I learned more about the legal side as a real estate investor. So it kind of went hand in hand, and that's the group of people I ended up associating with and getting business from.
Sure. Well, getting into our topic today, which is land trust. I know Sean and I have been talking for some time about this episode specifically because we get tons of clients in dealing with real estate. We'll get clients all the time that are like, oh, I read online this land trust, I got to do it. And we end up either referring it out or, but this has been a neat opportunity for us to really learn more about the topic. But let's start really kind of at the beginning here. As we've got a lot of real estate investors that watch our podcast, but a lot of new folks to the industry. What is a land trust?
Well, a land trust is a title holding trust primarily used for anonymity of ownership, although there are some other uses we'll talk about. Primarily your topic about a seller signing an executory contract, I'll get into that. It's a revocable living trust. It's in that category, but it's not the same animal as you would use for estate planning. It was invented in the 1950s by Chicago Title as a way for them to get fees as being a trustee by saying, hey, you can have anonymous ownership in a trust, and we'll be the trustee and charge you a fee every month. So that was the animal that was created, and close to 40% of properties held in Cook County are in land trusts. It's statutory in about 9 states. Florida comes to mind, Indiana, and a handful of others. But by common law and court cases, it's really a valid thing to use in almost every state. There's only 2 states where courts said we don't recognize these here, and that's Louisiana and Tennessee. And it was over a jurisdictional issue involving estate tax. But, as you know, the Uniform Probate Code says a trust may be created for any lawful purpose, and a land trust is nothing more than a revocable living trust to hold title to a single piece of property, with the idea of each property being under a separate anonymous trust with a trustee of choice who would normally be a family member or friend with a different last name to keep anonymity at a P.O. box. So tenants, code inspectors, attorneys, the government, anyone who wants to poke around makes it difficult.
Now, anonymity is obviously a big benefit. These days, as land trusts have grown in use, is that still the primary benefit? What are some of the other benefits, if there are any, to land trusts?
The primary benefit is anonymity. If you have a tenant and you have a property manager, you don't want to be on record as the owner. A lot of people use LLCs, but they form it themselves and they put their name all over the filing record, so easy to find you. So titling in a land trust with often the beneficiary an LLC or something like that for protection as well. But there's no requirement under state law that a trust have a registered agent in the state. So it could be a P.O. box, could be a P.O. box out of state, out of the country. And the individual doesn't have to reside or register to do business in that state. So logistically, finding information, getting service of process in a lawsuit, everything becomes more difficult. And that's the whole idea.
William, I wanted to touch base on, oh, sorry.
Go ahead.
I wanted to touch base on your use of the term revocable, because that has some significance, right?
Right.
And so we have some, obviously most people that watch the show are not attorneys. They're going to be, investors or lay people. What's the significance of the term revocable? What does that mean in layman's terms?
Well, in layman's terms, it means you can change it, terminate it, amend it, as opposed to irrevocable, which once you set it up, that's it. You can't change it. Both of those are subcategories of living trust. People think living trust, they think estate planning. Living trust just means a trust created while you're alive, as opposed to one created by a will. So living trusts are revocable or irrevocable. And of course, under those categories, there are dozens and dozens of subcategories of trusts. But a land trust is, in essence, a revocable, created while you're alive, living trust. But it's not the same as you would use for estate planning to pass your assets on to your heirs, although both are in the same category.
Let's talk a little bit about the potential use of land trusts to deal with, and it depends on the language of the lending instruments, but to deal with due on sale clauses, right?
Right.
Because there is a strategy, depending on, once again, the language of the lending instruments, where if you put property in a land trust, regardless of anonymity, it really doesn't matter at that point. But if you put property into a trust and it's revocable, then in theory, you can swap out the beneficiaries or the owners of the trust without actually conveying title to the property. And once again, you might be able to avoid the due on sale clause doing that, potentially, right?
Possibly. There is language in the Garn-St. Germain Act, which was enacted in the early 80s as a response to the whole issue of can lenders enforce due on sales, and Supreme Court said yes, and the federal government codified it, but carved out exceptions where a lender may not enforce a due on sale. And one of them is a transfer into a trust of which the borrower is and remains a beneficiary. So if you do put it in a trust for yourself, that's not triggering a due on sale. But if you change beneficiaries to somebody else, in theory, it could. And oddly enough, it says a beneficiary, not the beneficiary. So presumably, the other exceptions, like putting your spouse or your kids or other permitted exceptions, would be okay. A lot of people put properties in a land trust to take it subject to the existing loan without technically triggering off the lender to find out by putting it in a land trust, having the seller as the beneficiary, and then transferring beneficial interest to the buyer. And that's not of public record, so the lender doesn't notice it. But if they did, it would trigger it. I think that's it's academic more than anything.
Well,
I think it's a practical matter. Lenders really just, by and large, don't care.
Well, what about this scenario? Because you're talking more of your conventional lender, right? You're talking your traditional, hey, I'm going to go to a mortgage broker, obtain a loan, federally insured, whatever. Yeah, I agree with you. You probably can't use it there. But what about a scenario where I'm going to go buy a property using seller carryback financing, and I buy it in the name of the trust initially, right? I don't buy it in my name. I don't buy it in my LLC's name. I buy it in the name of my land trust. In that circumstance, and once again, depending on the language of the deed of trust, and the note, I might be able to basically exit that property without, having any issue with the due on sale clause, using the revocation and amendment provisions of the trust instrument, right?
Oh, certainly. If the seller's mortgage or deed of trust that he used or prepared, or the one you've prepared as the buyer for him, simply says, if you transfer title, it triggers the due on sale, then yes, you haven't changed title. You've just changed the interest under trust. The standard Fannie Freddie one is pretty specific. It says if you sign all or part or any interest therein, or if you're an entity, any interest.
Right.
It's pretty broad. People, we're not the first geniuses to think up this one. 50 years, people have been doing that. When interest rates were 19% and you wanted to get around a 5% loan, we did things like this. But yeah, it is a possibility. It's also a possibility. Let's say you have a seller, like a bank-owned property, and you're going to make an offer as a land trust, and the contract says you may not assign this contract. I'm not. I'm just assigning my beneficial interest in the trust to another person. who will then close in the name of the same trust that is the same buyer.
So are you telling me that as the market shifts, we can wholesale short sales doing it this way?
Well, that again, depending on the language, we did that a lot in the 2009 to 11 arena with land trust assignments where it said you may not resell the property, retitle the property within 180 days or 90 days. So that's what we did. But some short sale letters would say there's no assignment, transfer, and they were very specific about the things you couldn't do. Then we couldn't do it. And then sometimes title companies would get a little squirrely about the trust agreement because they didn't know what it was. So we started using LLCs to do the same thing and just assigning memberships.
Yeah. Now, on a short sale, and it's been a number of years. I've done countless short sale foreclosure consults, and I was very active back in the day. But it's been a number of years. Do you recall whether or not you could enter into the purchase contract with the name of the land trust? Was there any prohibition from entering into the purchase contract in the name of the land trust and then like a day before closing or a week before closing, swapping out ownership of that land trust?
It would really depend on the short sale approval letter from the lender. It would have conditions. Right. One of those conditions might be you may not retransfer title for the next 180 days. Well, we didn't.
Right. Yeah.
But if it says you can't assign it in any way, shape, or form, and it gets very broad in its language, then it gets a little trickier. Are we defrauding a lender here?
Right. Yeah. And you don't want to do that, right? I mean, land trusts are great and they provide a certain level of anonymity, but you also have a duty of, not to fraudulently conceal, not to fraudulently misrepresent. And, in no way should anything that we talk about today be deemed, encouraging or promoting any of thing like that.
There's nothing wrong with trying to hide the fact that you're getting around something from somebody, unless there's an affirmative duty to disclose.
Correct.
But if you're asked, don't lie.
Right. Yeah, that's exactly.
If the lender pins you down and say, "Did you change beneficiaries?" You got me.
Right.
Don't lie. And then it becomes potentially a federal crime.
Well, and it's up to the lender, especially in the short sale scenario, it's up to the lender to, dictate the rules. And, if it doesn't say it in the short sale letter, then you can do it. I mean, that's the bottom line.
That's what we as lawyers do.
Yeah. Yeah. Right. I mean,
you can't do, and we won't do that.
Right. Exactly.
Well, I want to a couple formation question talking about the land trust. So, given that it's a living trust, who is the grantor, the creator of the trust? Is it a property owner? Could it be somebody else? Who would that typically be?
Well, it depends on the scenario. If I'm buying in a land trust, then typically I do not. I mean, in the old days, what we used to do when we were buying a property subject to an existing loan, we would put the seller as the grantor and beneficiary of the trust, me as the trustee, transfer the property to the trust, wait a few weeks to see if the lender balks when we recorded the deed, and then assign the beneficial interest from the seller to me or my entity or my LLC. I just found that it becomes confusing for the seller to explain it. And then later on, an attorney comes back and thinks that he might have an interest in that trust. So what I do is simply taking it subject to directly to my own land trust, where I'm the beneficiary and trustee, or one of my entities is, and they just deed it straight into my own trust.
Are there situations when you're forming a land trust for a client that it makes sense, or that they opt to do it in irrevocable fashion, so they make it an irrevocable trust?
I've had a few people request that, and I talk them out of it, because especially in the scenario where they already own the property and then they want to put it in a land trust, you've got gift tax implications depending on whether or not it's a grant or trust. So usually I advise against it. There's other types of irrevocable trusts we could layer underneath the land trust to accomplish what they're trying to accomplish. But the basic animal is a revocable, simple, revocable living trust.
So you mentioned taxes, and that's kind of a good transition to that question, which is, how are they taxed, and does a land trust require an EIN?
It does not require an EIN unless you're going to try to open up a bank account for one, which is not recommended because trying to find intelligent life form in a bank is difficult at best. What we usually do is with a land trust is, if let's say I own a property in my own name and I transfer it to a land trust and I'm the beneficiary, there's no change in tax reporting there because it's a grantor trust, which means grantor, me, is still the owner. The IRS looks at that as, well, since I can revoke it, it's still mine anyway. So I report the same. So if it's my principal residence, I'm going to report it as my principal residence. If it's a rental property, I'll continue to report it as my rental property. If I change beneficiaries, that's different. If I change the beneficiary of the trust from me to, let's say, an S Corp, well, then the S Corp would claim it as its ownership. So whoever the beneficiary is really the taxpayer.
So you mentioned an S Corp, which, just to be clear, an LLC can be taxed as an S Corp. It doesn't have to be an actual corporation. And so how does a land trust work, or can it work in conjunction with an LLC, and how?
Right. We can make the beneficiary of the land trust, let's say an LLC. Let's start simple, a simple disregarded single member LLC. So if I'm the sole owner individually and I transfer it into a land trust where I'm the beneficiary individually, and then I change beneficiaries from me individually to a disregarded single member LLC, nothing's happened for taxes there. I'm still reporting at Schedule E my own rental property because the trust is ignored and the LLC is ignored. Now, if it's an LLC husband and wife as a partnership, that's different. Then the beneficiary as an LLC partnership would be filing on an IRS Form 1065 as a partnership and receiving K-1s. Or if it's an S Corp, it would be, that way K-1s as well, and reporting on an 1120S, an S Corp return. The general rule is whoever the beneficiary is, that's the taxpayer. That's who's reporting the income and expenses of the property.
Why would you want to use an LLC as the beneficiary of a land trust? What's the purpose?
Well, the reason is because a land trust, even though it provides anonymity and some protection from some types of claims, which I'll outline in a minute, generally it doesn't provide liability protection like an LLC. The beneficiary is calling the shots, unlike in a normal trust where the trustee is calling the shots. So if the beneficiary calls a bad one, then he's liable for someone, like say, for example, being injured on the property. So the LLC is the protection shield. The land trust is the anonymity layer. So working together, combined, it's beautiful because it gives you both. As you know, filing an LLC with the state, unless you use a registered agent service and an attorney or service to file it for you, your name's all over it.
Correct. Yeah. And unless you file, in Wyoming or Delaware, those types of things, and use.
And even still, half the states require the name and address of the manager of the company, which is the individual. So that gives it up too. So if you want to deal with a tenant and say, I don't own the property, I just work for the property management company, it's beautiful. If it's in a trust, because if they look it up, they go, oh, it's not Bill, it's some anonymous trust with a trustee at a P.O. box in Minnesota. And they don't know who's underneath or what company is underneath unless they're writing checks to that company. But what I usually do what I personally do is I have multiple LLCs and multiple trusts, and then I have a property management company collect rents from everyone, and I say I work for that company.
William, is there a limitation on the type of property that can be put into a land trust?
Well, not really. The only thing I can think of might be like a co-op, um, where there's a board where you have to get approval, or maybe a timeshare where there's specific rules against it. But a condo, a commercial, some multifamily, residential, industrial, anything that has a deed for title can be placed in a land trust.
Now you've mentioned, and we've talked about kind of the interaction between a land trust and an LLC. I'm curious, and you also mentioned the idea of putting property in the name of an LLC and swapping out membership interests. What's the benefit of using a land trust over an LLC or vice versa? Why would you want to hold title in a land trust as opposed to an LLC? Because it seems like both of them kind of accomplish a similar purpose, and can provide anonymity as well as, the ability to change ownership without conveying title. What's your thought? When do you put it in an LLC? When do you put it in a land trust?
Right. So each property, I recommend titling in a separate trust. And that way, let's say a code enforcement person looks up the owner of the property and sees, an XYZ trust. And then they look up that name and see what else it owns, and it doesn't own anything else. Like in my jurisdiction where I own rental properties, if you get more than 3 violation notices, like, cutting your grass or a dead tree in a 6-month period, you got to go to court and a judge could potentially throw the book at you. Well, if every property is a separate landlord, hard to do. Now, I don't use a separate LLC for every property. I think that's overkill. But what I do recommend generally is maybe every 3 or 4 properties, depending on how much equity there is, would be owned by an LLC. So it might be 3 land trusts for 3 properties, but the same LLC is the beneficiary of all 3, as opposed to putting multiple properties directly in an LLC online where you can cross-reference ownership.
What's the process of forming a land trust as opposed to, say, forming an LLC?
Much simpler. So a trust is a contract. It's not an entity. You don't form it with the state. It doesn't get an EIN. It's, if anyone here is watching and has ever done a living trust, you print out paper, you sign it before a notary, and voila, it's created. And the same thing with a land trust. It's just 8 or 9 pieces of paper, a couple of signatures, and a notary stamp, and it's created. And then it has to be funded, which means you have to put assets in it, which means you're either buying it via a deed or you're transferring existing property you have into a land trust via a deed. And that's basically it. You're up and right. A few other intricacies, but that's the gist of it. It's not very difficult. There's no annual fees. There's no registered agent. There's no filing fees. There's no tax return. There's no EIN, and it doesn't need a bank account. It's paper.
So contrast that to forming an LLC. What does that look like?
Well, an LLC requires a bank account, an EIN number, a filing with the state, maybe franchise tax, depending what state you're in, maybe other taxes, annual reports, annual filing fees, registered agent in the state, which you may have to pay if you're not your own registered agent, and an operating agreement. And it's a to-do. So having a land trust for every property, but then having an LLC underneath that as beneficiary every maybe 3 or 4 properties is very effective, because 1 property per LLC is overkill unless we're talking about multi-units. So if you have 3 condos and 3 single-family houses, 6 LLCs would be overkill. Maybe you'd have 2 and then 6 land trusts.
Yeah, talk to us about that, because I know this isn't an asset planning thing, but nevertheless, it's always good to speak with somebody experienced on these matters. Because I have Andy and I have a lot of clients that come to us and like, oh, I've been told I need an LLC for every property. I was like, oh, so are you ready to, you own 10 rentals? Are you ready to have 10 checking accounts and 10 books and 10, EINs and whatever? Oh, well, that's a lot of work. So talk to us about kind of your theory, because mine is, 3 or 4 per LLC. You look at the equity as well. Like, hey, man, if I put 4 properties in there, but they each have, 20,000 in equity, like who cares, right?
Exactly.
So you have to look at the equity too, versus say, one property with $1 million, you may want to separate that out, $1
Right.
million
Well,
in equity. So what's your
there's
theory?
Right.
What's your theory on
Cost,
all of this?
aggravation, bank accounts, accounting, paperwork. I mean, you want to be so busy having corporate meetings with yourself, you won't have time to go buy real estate. So, and the other thing is, I think the argument going into court, you go into court and say, Judge, I've got 100 properties and this tenant got injured on property 3, and property 3 is owned by one LLC, and that's all they get is the equity in that property. And the other lawyer is going to say, don't fall for it, Judge. It's all him. We want all 100 properties equity. You're not leaving the judge with a lot of leeway there. So don't get too cute. Maybe throw him a bone, throw him 3 properties instead of 20 properties or 100 properties. So, and again, if you can't maintain the separateness, separate accounting, separate bank accounts, separate books, it's very hard to make the argument with a straight face in court that they're really all separate.
Well, and that's just it. And I think you would agree. And I always tell my clients when they come to me and, I need to protect my assets. And I say, okay, I can help you to an extent, but your first line of defense is always good insurance. You better have good insurance, right? I mean, that's your first line of defense. If it gets past there, I mean, honestly, if you have a good, say $500,000 policy plus a nice, balloon or umbrella, I say balloon, umbrella policy, you have an umbrella policy, man, you're talking protecting like 99% of accidents, with that type of coverage. And it's not that expensive. And it would save you a whole heck of a lot of time. So I always say insurance first, and then we can do what we can on the back end to provide that extra layer of protection.
Yeah. All this stuff is secondary insurance. That's what it is. It's catastrophic insurance. But trust has other uses too. So for example, we talked about earlier, you guys were talking about a seller on a contract for deed selling his interest to someone else to cash out. Well, he'd have to transfer the deed, assign his contract, and a couple of other documents. If he owned the property in a land trust and the land trust sold via the contract for deed, all he has to do is assign his interest underneath the trust to somebody else in one document, one page. I bought properties that way. I bought properties from a client who was in a divorce, and he had property sold on contracts for deed, and he needed to cash out. So I just did an assignment of his land trusts to me. That's my IRA, actually, but that's another discussion.
So a sophisticated seller, maybe in an investor who's in on the property, and now they're doing a disposition via a contract for deed agreement for sale, maybe to make things easy so that they could exit at some later time, maybe put it in a land trust. And so, they're going to be the seller / lender, but you don't have to do a bunch of paperwork. You just simply swap out, the beneficial interests of that document, and you're on. Yeah.
I actually sold a property that way. I was selling a condo that I had up in the ski resort mountains area, and I put an ad in the newspaper to see if I could for sale by owner it. And I got someone who called me up and said, well, I have a couple of condos in Denver. I'll trade you. And I said, how would that work? He goes, well, I have them in trusts, and you can put yours in a trust and we'll swap beneficial interests. And I said, that's really creative. I said, where'd you learn that? He goes, I went to the seminar by this guy, Bill Bronchick. So that's what we did. Awesome. I had my property in a land trust already, and she had hers, and we just traded beneficial interests.
Very cool.
Yeah.
So I'm going to throw you a curveball, and you may already know about all of this, but here in Arizona, we have this statute that says that any transfer into or out of a trust, you must disclose the names and addresses of all beneficiaries. So any transfer. And if you don't, it's not a valid transfer, and title, you can't get title insurance, and it's a real mess. You have to do it. So how does a land trust work in that scenario, and what are the ways around that?
Yeah, I'm familiar with that. And I think there's a 2-year rescission period for either side of the transaction. Now, if I own a property and I put it in a land trust, I'm on both sides of the transaction. Who cares? I mean, I'm not going to revoke myself. But if I'm buying from a seller into a land trust and I don't want to disclose the beneficiary, there's a couple of options. One is I buy it in an LLC, and then which requires no disclosure, and then after that, transfer it by deed into the land trust, which again, I'm on both sides of the transaction, so no risk of rescission of either party. Another thing we use is called a personal property trust, which is like a land trust, but for personal property. RVs, boats, cars, or beneficial interests in land trusts. So if we made the beneficiary of a land trust a personal property trust, we disclose on the transaction that the beneficiary of the land trust that's taking title is another trust known as XYZ Anonymous Trust, PO Box, whatever. And we've complied.
Yeah. Yeah, no, that's good. And another way that I've seen people try to do an in run around it, and I think it works, is to properly form a Wyoming or Delaware LLC that's completely anonymous, and make that the beneficiary of the land trust. And then, you disclose that plus the registered agent's address, or the domestic address of the LLC, which is some Delaware or Wyoming address. And then you won't know who owns it. So that's another way around it. But yeah, and that's the one thing about Arizona. I don't know if Colorado's the same, but there's really there's no anonymity in Arizona, so we can list off some professional and stars and stuff that live in. Give me 5 minutes and I'll give you their address and who holds title and the whole thing, because there really isn't. It's very difficult to establish anonymity, which is why this conversation is so important, because there's ways to do it. It just takes a few extra steps here in Arizona.
Yeah. Hawaii has the same disclosure requirement, by the way.
Oh, okay. Yeah.
Yeah, it's the same thing. We just put another trust under the trust, or put an LLC that it's like an all-purpose single-member Wyoming anonymous LLC that we take title for 10 minutes and then transfer it out to the trust.
Yeah, or just exactly. Or you just make that the beneficiary from the get-go on there, because the only concern with that strategy, in my mind, is the potential impact on title insurance, doing it that way. I would be a little uncomfortable with that, because title's not going to, if you're moving it into a trust and you're not disclosing, title's never going to provide that insurance. So you have to make sure that, you're not doing anything that's going to interfere. And the more you transfer after you get your insurance, you're supposed to go back in and get endorsements and stuff like that. You're not. And so that would be my only concern. I like the strategy that you listed, which is, hey, why don't we just form two trusts, and make the secondary trust the beneficiary of the first trust, and have the trustee or the beneficiary, put an address down that maybe isn't identifiable, that would be deemed their address, or alternatively, having the LLC, the Wyoming LLC, and take title just directly in the land trust. Because then when you do your deed, you can fully disclose the beneficiary of the land trust is this Wyoming LLC with this address. So yeah, interesting.
Absolutely. I mean, for every rule, there's always kind of a way around it. If you get creative. And the biggest downside is just something that you alluded to, which is land trusts become complex with title insurance, because 9 out of 10 title companies will tell you those are not legal in this state. Unless you're in Illinois or Indiana or Florida where they're statutory, they'll say, we don't recognize these here. And that's not true. It doesn't mean they're illegal. And I love when lawyers go, that's not legal. And I go, what law is that? So it's not illegal in the sense that it's a criminal act. It's just that there's very little supporting law for it. Like in California, there's a Supreme Court California case that's the recognized land trust, and 9 out of 10 escrow companies in California will tell you they're not valid here.
Right.
So
and we use the word land trust, but it's just a revocable trust that's created to hold title. It's take your family trust, so and so and so and so, revocable family trust dated blah 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 blah. Take that and just swap out and come up with some creative name. This Sun Devil revocable trust, okay, and swap out a few names, and that's the same thing. You're just creating a trust, a revocable trust. You can give a trust any name. We just,
Sure.
think it's nice from a legacy perspective to use the husband and wife's name as the family trust. And I was like, oh, we have a family trust, but you can put any name in there you want, right? It doesn't matter.
As long as it's not violating someone's trademark, you can call it.
Right.
I've
Exactly.
had
Right.
get really cute and call it, most people do it the address. So 221 Martin Street Trust. But I've had clients call it the Catholic Women's Foundational Children's Trust. It's legal. It's probably going to throw people off. It's cute, it's creative, but there's nothing illegal about that.
Right. And there's nothing prohibiting people from having multiple revocable trusts. Now a question on that, from an estate planning perspective, let's put the anonymity issues in Arizona aside. Let's just talk Colorado, for example. Let's say that the investor has been proactive in doing even estate planning. You mentioned you do some estate planning. So they've gone and they've done their, family living revocable trust, right? I mean, they have it done. They're ready. They've taken care of their children and they have their legacy in place and they've done what they want to do there. But now they're going to invest and they say, well, William, we want some anonymity. We want to use a land trust for our investments. In that case, can you make their revocable family trust the beneficiary of that land trust, assuming you don't have to disclose it? Huh?
Absolutely. In fact, I would even recommend for a principal residency. Absolutely. Mm-hmm. For a rental property, you could do it in 3 layers. Land trust owns the property. LLC is the beneficiary, member of the LLC living trust.
Yeah. And you've established your asset protection and you've established your probate protection. You're not having to go through probate if you structure it that way. Yeah, brilliant. I like that. Yeah.
Yeah, that's how I usually do it. I usually tell them because most estate planning attorneys will say, okay, we formed the living trust, put all your assets in it. And that's not wrong for estate planning, but it doesn't protect you in any way or give you any anonymity. So you put your layers in place, and at the bottom is where you put your living trust. So if you have multiple entities, then the entities are owned by the living trust.
Very interesting. And that's important too, because when you talk about the primary principal residence, and you mentioned, don't have that LLC in between on that, primary or principal residence. And the reason is because of the homestead. We've talked asset protection, and I always tell my clients, well, in Arizona, you have a homestead, and that is going to be better than anything else I can do for you. And so let's not ruin that by getting fancy with LLCs and anonymity and those types of things, at least here in Arizona. Right. So I like that. So the reason why you're suggesting, hey, for your primary residence, you could put it into a land trust and still have some of that anonymity, followed by your family trust as being the beneficiary. So you're still preserving the homestead exemption, but providing that extra level of anonymity. We can't really do it that way here in Arizona, but I love being able to do that in Colorado and having
a living trust doesn't retain your.
We can, but I can't give my clients anonymity doing it that way.
Yeah. Okay. I understand.
Because of the statute. I can't give them anonymity that way.
I understand that.
Yeah. We could still do it and it's preserve the homestead, but what's the point when there's no anonymity anyway?
No anonymity. I understand.
Yeah.
William, I'm curious, what would you identify if I've come to your office or somebody new says, I want to do a land trust, we're doing this. Are there any downsides I should be aware of? I mean, or what are the major downsides I need to be aware of if I choose to go that route?
Well, the major downside is what we discussed earlier, which is general ignorance. So title companies and other attorneys mostly, and are telling you that's not valid, that's not legal, we can't insure it, we can't do that. No. So it's a matter of educating people. The other downside might be refinancing. So if you put it in a trust and then you want to get a Fannie Freddie loan as a refi, you can't do it in a trust or an LLC or anything. It has to be in your own name, which means if you were going to get a Fannie Freddie loan, conforming loan, you'd have to quit claim it out of the trust into your own name, refi it, and quit claim it back, which leaves a trail on the chain of title. Not ideal. But I've refinanced with like local commercial banks, commercial branch banks, and they said, we don't care if it's in a land trust, an LLC, whatever, as long as you guarantee the loan, when we can get a lien, we don't care. So it's mostly a Fannie Freddie regulation that they only lend to individuals, not entities, and that's residential financing, not commercial.
Now, back to the estate planning question and coordinating. If you're dealing with a client who has done estate planning, or you're helping with them with that for them as well simultaneously, do you usually recommend that they try to coordinate who their agents are going to be? In other words, try to make the trustee of the land trust the same as the trustee on their main family trust for convenience sake, or are there downsides to that? How do you usually recommend dealing with that?
Logistically, it usually ends up being the same person. If they trust this person for this, they trust this person for that.
Sure.
But not always necessary. Sometimes people do put, a friend as a trustee. A strategy for people who don't want to be a trustee and be on title, and have that potential, threat of risk for being on title. So let's say I have my neighbor be the trustee on title, record the deed, and then have him sign a resignation affidavit appointing me as the backup trustee. And we put a PO box that I have the key to, or a virtual PO box that I have control of as the mailing address. Then, my name's off the record, but the only challenge with that is if someone tried to serve a summons on my neighbor and they said, I'm not the trustee anymore, then what?
Right.
Someone maybe does a service by publication and you don't get notice of a lawsuit. So there are risks to things like that.
Well, William, thank you so much for being with us today. Where can our audience find you? What's the easiest way for them to see what you're up to, get in contact?
My law firm website is bronchicklaw.com, Bronchick. It's the only family name of that spelling. And I also have a website called legalwiz.com, where I have real estate investing information and advice and products and things like that.
Are you, do you have any, are you on any social media platforms where they might find you?
Same name, Bronchick. YouTube, Bronchick. YouTube, Facebook, Bronchick. Same thing. I got it all. It's a really easy one because it's a unique name.
All right. Facebook, YouTube, and the World Wide Web. You can find William Bronchick. William, thanks so much for being with us. We appreciate it. It was great information.
Pleasure. Thank you for inviting me.
Till next time. All right. All right, everybody. That is our episode for today. Join us next week. The topic is going to be attorneys, good ones, bad ones, what to look for and what to run from. We have a number of guests, Pace Morby, Logan Fulmer, Tyler Epstein, and Sean and I will be there. Join us. We're looking forward to it. We'll see you next week.
Have a good day, everyone.